When does a living trust not avoid probate? What's up, everybody? My name's Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. And before we begin with that question, if you have any questions related to estate planning or probate and you live in the great state of Alabama, you can speak to an attorney for free by going to keylawllc.com. We'd be happy to speak with you and see if we can help you out. Now, on with the question. When does a trust not avoid probate? Well, typically, just as a review, probate is a type of court process that takes assets and goes through this process and distributes them out to beneficiaries. And that's either done with a will, or in the event that there is no will, they divide it according to statute. So, the premise of a trust is to be able to have assets placed into a kind of a trunk or a treasure chest, and it gives the trustee the key, and you have a contract between yourself and the trustee to distribute those assets in accordance with your wishes that you've laid out in writing. Now, why would you need probate? Because that person would already have the legal authority to be able to do that and to be able to distribute that. Well, there's two ways that can occur. So first of all, one of the biggest mistakes that people make when drafting and creating trusts is that they don't fund the trust properly. So assets that are not titled in the trust's name, or beneficiary forms, or other assets that are not put into the trunk, so to speak, would end up having to go outside of that trust and would need to be transferred to beneficiaries in some way, shape, or form. The other thing is sometimes you can get checks from retirement homes, tax refunds, and different names that would go to the estate itself instead of the trust. And so those are a couple of reasons why. So basically it comes down to when you have things and assets that do not follow the trust, that at some point in time will probably need to be probated. Now, when that occurs, probates fortunately can be a little bit simpler than the normal process that you would, say, if you didn't have a will. And there's two reasons for that. One, if the trust has been funded, those assets in there will not need to go through probate. So the amount of assets and the amount of workload on that front to roll through a probate would be relatively small, or at least smaller, with the trust being in play. And then secondly, when you draft a pour-over will, typically the person named as the executor, or the personal representative, so to speak, typically will be named as the same person as the trustee of the trust. So you would only have one person that would take care of all of this and would be able to sit down and manage those assets and make sure that they get out. Now, it's still probate and there would still be some time, but the other part of it is that those assets that are in the trust would immediately go to the beneficiaries. They would be able to be collected upon. So it makes the probate a little bit simpler and a little bit easier. And so that's when you would have assets that would go through probate even though you had a trust. That's going to be it for today. Again, if you have questions about this or anything related to estate planning or probate and you live in the great state of Alabama, we'd love to speak to you. You can do so by going to keylawllc.com. Again, my name is Josh Key. I'm the managing attorney at Key Law. We'll see you on the next one.